Okay, good afternoon, everyone. We'll get started. My name is John Tuxell. I'm faculty here at Fairhaven College. I'm teaching the World Issues seminar this quarter. So welcome to our second World Issues Forum of the quarter. We're delighted to have with us Judge Raquel Montoya-Lewis, Associate Justice of the Washington State Supreme Court, with us today to talk about therapeutic and restorative practices in state and tribal court systems. Before we get started, I'd like to first offer a land acknowledgement. Western Washington University's main campus is situated on the ancestral homelands of the Coast Salish peoples who have lived in the Salish Sea Basin all throughout the San Juan Islands and the North Cascades watershed from time immemorial. We express our deepest respect and gratitude to our indigenous neighbors for their enduring care and protection of our shared lands and waterways, and may all of our collective stewardship live up to that standard. I would like to also thank the co-sponsors of this week's World Issues Forum. That includes the Foundation for Western and Alumni, the WWU Tribal Relations Office, the Native American Student Union at WWU, the Center for Law, Diversity, and Justice, and the Ray Walpole Institute. So I'd like to hand the microphone to Fairhaven's Dr. Ceci Lopez, who will introduce our speaker today.
It is my pleasure to introduce to you Justice Raquel Montoya-Lewis, who is an Associate Justice with the Washington State Supreme Court. She was appointed by Governor Jay Inslee in 2019 and won a full term in a contested election in 2020. Prior to that, she was a trial judge for 20 years, serving as a Whatcom County Superior Court judge and a tribal court judge for the tribes of Washington and the Southwest. From 2003 to 2015, she was an associate professor at Western Washington University Fairhaven College. Justice Montoya-Lewis holds a BA degree from University of New Mexico and a JD and an MSW degrees from the University of Washington. She is an enrolled member of the Pueblo of Isleta and a descendant of the Pueblo of Laguna and the first Native American on the Washington State Supreme Court. Thank you.
Thank you, Professor Lopez, for that introduction, and thanks to everyone who's here, whether you're in person or online. I'm thrilled to be able to be back at Fairhaven. Are you all able to hear me okay, or do I need to speak louder?
Okay.
Okay, thank you. So I'm going to share my screen in just a moment, but wanted to just say a couple of words before I do that. I was given pretty free rein to talk about whatever I felt like talking about today. And I wanted to kind of give you some information that can be really hard to get in terms of what tribal courts do and the framework that tribal courts work in, and what that means or can mean for state courts. I'm in the unique position to have been able to serve both multiple tribes and the state. In my career, there are very few judges who have been tribal court judges who get the opportunity that I've had to sit on the state court. So because I have those two sets of very different experiences in a similar role as a judge, I've had the opportunity to really compare those experiences. And so I want to share some of that information and that experience with you. And I'll also be happy to take questions towards the end of our time together, and want to encourage you to ask questions that are beyond the scope of my talk today. If you're interested in hearing about how our Supreme Court works in the state of Washington, how we decide what cases we're going to hear. Those are often really common questions I get. I'm happy to talk about that and anything else you're interested in. So please feel free to ask questions when we kind of get to that time. So I'm going to start here by sharing my screen. hope this works. Looks like we're good. Okay. So, as I said, I want to talk a little bit today with you about what we are able to learn from tribal courts. And so I'm going to start doing that by talking first about what the legal context is for tribes and how we are tied to what the federal government does and to a certain extent what state courts do. So in order to have a thoughtful conversation about how tribal courts work, you really have to understand this very unusual relationship that tribes have with federal and state governments. And it all starts with the treaties. Treaties are often referred to in a shorthand as the law of the land. You see that in cases that go back 250 years in our jurisprudence in this country that say that treaties are as important originating documents that define the relationships between the federal government and the sovereign nations that pre-existed our U.S. federal government's existence by many, many hundreds of years, or as your land acknowledgement recognizes, since time immemorial. That language, time immemorial, is language that is found in multiple treaties around the country when the federal government sat down and entered into binding legal agreements with multiple sovereign nations throughout this country. And so those documents, those treaty documents, are as important as the Constitution, as other founding originating documents that we use to understand the law in this country. So it's hard to overstate the importance of what those founding documents say, and that's critically important to the continuing existence of tribes, to understand what the treaties say, how they define our relationships, and that's the place where you start when you want to understand what's the authority of a tribal government to act. So we start with the treaties when we start thinking about what are tribal rights, because the treaties often have language in them that is different from what you might see in other kinds of agreements that tribes enter into with the state and federal government. So one of the pieces of language that gets talked about a lot is that time immemorial language. When we talk about the rights of tribal hunters and fishers and others that are utilizing natural resources in the area that in treaties is referred to as the usual and accustomed places or boundaries. And what that's referring to is it's effectively saying, if you're a tribal member and historically your tribe has utilized the salmon in this area, the treaty with your tribe guarantees your ability to continue to engage in the practice of subsistence hunting and fishing. And so those tribal individual rights that are held by tribal members are also rights that are held by the tribe. And that gives rise to all kinds of complicated and ongoing litigation, some of which has been going on for 75 years in some cases. So in the state of Washington, there are 7 treaties that have been signed by either the territory of the state of Washington on behalf of the United States or the United States itself. Those treaties are easily accessible if you just Google them and you Google the Washington State Governor's Office of Indian Affairs, go to treaties, and you can look at the treaties themselves and read for yourself what they say. So there are, as I said, 7 that cover most of the tribes in the state of Washington. And as I said, you can access those and take a look at them. But there are some other important things to be thinking about when you read a treaty. One of those things is this foundational concept that first comes up in cases that went to the United States Supreme Court at the earliest stages of the founding of this country. And one of the questions that these treaties gave rise to was how do we as a federal government work with sovereign nations that have their own governments, meaning the tribes? How do we ensure that they continue to exist, but also are in relationship with the federal government, and we continue to have power over what tribes are doing? It's a very delicate balance, and it started with this concept that the U.S. Supreme Court adopted in very early cases, first setting out the relationship between tribes, the federal government, and how the treaty rights enumerated in all of these treaties around the country define those relationships. And this foundational concept that's on the screen now, Congress has plenary power over tribes, is one of the most important aspects of understanding this relationship, because it's not the same as the federal government having a treaty with the country of Spain. We recognize those other countries with sovereign rights over their own country. We have a different relationship as a federal government with those governments than we do with the sovereigns that we deal with within the boundaries of the United States. And so the question became a big part of the early jurisprudence of the United States Supreme Court, which was how far does this authority that Congress has over tribes go? And the answer is it's effectively absolute or plenary. Our U.S. Supreme Court has said over the last 230 years or so, repeatedly, that we do have a relationship with tribes. They are sovereigns, but they're not sovereign in the same way that the country of Canada is sovereign. The early cases describe us as having a quasi-sovereign status as tribes, and that status is curtailed by this authority Congress has to decide whether or not tribes fundamentally exist. So we couldn't decide tomorrow, we no longer recognize the government of Spain, and they no longer have a functioning government because we said so. But in our country, the federal government could make that decision tomorrow if it wanted to. It places tribes in a very tenuous position when the existence of the tribes is really dependent upon the recognition by the federal government of those tribes. So you may have heard when Professor Lopez was introducing me that she used the term federally recognized tribes. I am a member of a federally recognized tribe, which means that the federal government has a list of all of the tribes that they recognize. There are tribes in the United States that are only recognized by the states. Those tribes tend to be in the southern part of the U.S. They're in North and South Carolina, in Georgia. There are some beyond that, including in Oklahoma. And we have a few in the state of Washington as well. And there's a whole process by which tribes can seek to have federal recognition. The reason that matters is because once you have federal recognition and all of these other duties that the federal government has to ensure the continued existence of tribes, the protection of tribes, the protection of tribal members kick in when federal recognition happens. So very recently, earlier this, I guess it was late last year in 2025, the federal government recognized the Lumbee tribe of South Carolina, South and North Carolina, actually. I'm not saying Lummi, I'm saying Lumbee, Lumbee. If you look into the history of the Lumbee Nation or the Lumbee tribe, they've been trying to get federally recognized as long as I've been aware of this process, so about 35 years. And I think their process of getting recognized started before even I was in college. They've been doing this for years and years and years, decades. They finally were able to get federally recognized at the end of 2025. And as I said, it's a complicated process of going through that. The reason to do it as a tribe is because then the tribes may be able to get a land base as a result of federal recognition, and then access, as I said, to the ability to negotiate with the federal government, as well as additional things like access to the Indian Health Service by individual tribal members. All of that could go away if Congress decided tomorrow that it no longer wanted to recognize no longer wanted to recognize tribes as federally recognized. They could simply decide that tomorrow. Still leave this question open about what do we do about the treaties, but there's no question under U.S. Supreme Court law that Congress has this fundamental absolute power over tribes. There are exceptions to that, but the way I think about it is that those exceptions exist kind of at the pleasure of the federal government, which could make a choice to change those. They have chosen not to up to this point. But as you all, I'm sure, are aware, that's not something that we can depend on as individual tribal nations at this point, because when we have sort of a mercurial federal government, which we're sort of in that situation of now, we could end up, sorry, I'm standing up because I'm in a room where my lights go off if I don't move. So it gets very dark in here, sorry. Okay, so plenary power over tribes is something that is really important to understand when you think about what tribes can do, what they are doing, and what they can be allowed to do in the future. So we have a unique relationship with the federal government that's not really like anything else. And so it's very difficult to look for and find analogs to this relationship in other areas of the law, because it doesn't really exist. We are in this unusual relationship with the federal government as sovereign governments that exist at the pleasure of the federal government, but also with this sort of unique situation of having agreements with the federal governments that are foundational to the founding of the country. The other thing that's important to be thinking about when you think about what tribes can do and what tribal courts do is the concept of the doctrine of discovery. This doctrine, again, comes out of very early case law dealing with this question of what do we do about the fact that there are sovereign nations in this country we have now decided is the United States of America. How do we have a relationship with these pre-existing governmental entities? And one of the answers was the U.S. Supreme Court looking to this concept called the doctrine of discovery. This doctrine comes out of the Catholic Church, and it was foundational to a lot of the countries in Europe engaging in the practice of colonization and doing it under the banner of a pre-existing governmental body. So Columbus came to this part of the world under the Spanish flag. That is to say, he was on boats that were owned by the Spanish crown. So when he discovered, quote unquote, this country, then he took title on behalf of the crown, meaning that the idea is European countries discovered this land, kind of ignored the fact that there were already people here, and said, we take this land in the name of the British government, the Danish government, the Spanish government, the French government, depending upon where it was that these white people first landed in this country and discovered it on behalf of sovereigns. They were contractually obligated to conduct their sailing under the crown of these other countries. And then that over time became, through war and so forth, became the federal government, which continued to have a relationship with tribes under this concept of the doctrine of discovery. In very basic terms, it means these particular white folks from Spain or from Denmark or from England discovered you first. And so this country is now under the authority of that sovereign. Really gave no legal authority to the tribes, except for this sort of offshoot of the doctrine of discovery, which is the power to dictate what the government, meaning in this case the tribal governments, can continue to have authority over, but to do so under what is often referred to as a teacher-student type of relationship, meaning the federal government is the teacher, and the tribes were in the posture of being students to the federal government to learn how to run a government. So I'm sure these concepts are running directly at odds with what you have learned up to this point about what the authority is of tribes. And it should run into that. You should feel a certain sense of cognitive dissonance hearing me talk about these 250, in some cases much older than that, concepts that somehow apply to tribes that exist today. This framework that I'm describing around how the treaties work and how they dictate what our relationship is with the federal government and what that means for the day-to-day lives of tribal members, it seems like it couldn't possibly be the case that these laws and rules that came to the United States through a Catholic church, that could possibly be impacting how things work today. But I'm here to tell you, it absolutely does. There was sort of an amusing side note. I have to be careful about my discussion of any current politics because I don't want to be in a situation where I might have to recuse from hearing a case that raises one of these issues. So I'm very thoughtful and careful about how I describe what some of these problems are that this gives rise to. But I am here to tell you that there are very current issues related to the doctrine of discovery that impact people like me on a daily basis. I'll give you one sort of amusing example to the extent that you could find any humor in this. As tribal people, we communicate through humor. I'm going to talk about that in a moment and how that's related to the work of judges. But for a moment, I just wanted to step into politics and use an example from current politics. Our current president said a couple of days ago that the country of Greenland belongs to Denmark only because, and this is a direct quote, someone 500 years ago sailed a boat there and decided that the country belonged to Denmark, that the country, that they claimed the country for the country they were nationals of. It was an ironic statement because what he described is the foundational concept for the relationship between tribes and the federal government. And if you were to say today, we no longer follow the doctrine of discovery and we repudiate the doctrine of discovery, if we said that as a federal government, that would mean that we get rid of this concept that if we discovered it, it's ours, which puts us in a situation where tribes might not be quasi-sovereign governments. They might be fully sovereign governments. And that gives rise to all kinds of problems that have developed over the course of the last 250 years as this relationship between tribes and the federal government has been developed through our case law and our statutes, the actions of Congress, the actions of the United States Supreme Court, and to a lesser extent, the actions of individual states in relationship to tribes. It throws all of that into very serious question if this country effectively repudiates the doctrine of discovery. It could be a good thing. It could also be a very bad thing. And there's a common phrase I'm sure you've heard, the devil you know is better than the devil you don't. This is one of those situations where anyone who practices in the area of federal Indian law heard the president say, hey, just because you sailed a boat here and decided it was yours doesn't mean it's yours. to be a very radical thing to say. I don't think he understood it to be as radical as it was, but it's also a terrifying thing for people who understand federal Indian law, because it throws all of these concepts that are up on the screen into question. So I start here and spend a lot of time talking about these concepts because I want you to understand that what I'm about to share with you about how tribal courts work and what we do and why we do them the way we do them and how that's related to the ongoing efforts to preserve culture and tradition in tribal communities, all of that is very tenuous right now because we don't have an ability to predict what the federal government is going to argue in court. And we particularly don't have that when we hear the president calling into very serious question concepts that the entire relationship is based upon. So with that said, I'm going to jump into talking about tribal courts in some more detail. So any federally recognized tribe can establish a tribal court. If I were in the room with you and I could see you all, I would ask someone to tell me how many federally recognized tribes are in the United States right now. The number changes because sometimes the federal government recognizes new tribes, as I just described. But we're at around 580, I think, right now, federally recognized tribes. So what that means is that there are individual sovereign nations that the federal government recognizes as individual sovereign nations operating within the United States, functioning as governmental entities. And any one of those tribes can choose to establish their own tribal court. Many tribes don't. There is no stable amount of funding that comes to tribal courts if they are established. And that means that not all tribes have the ability to have a tribal court because it's very expensive. You have to, pay the court staff, you have to have a place to hold court, and then you have to do all of the things to follow up and make sure that people follow the court's orders. And if you're talking about the criminal system, then you have to have a whole system laid out so that people have access to counsel, that they have the ability to comply with court orders. All of that starts to happen once a tribal court is established, and no tribe gets any reliable source of income to run their tribal courts. So if they don't have their own economic base, then they may not have the ability to fund their tribal courts at all. Most tribal courts live and die by federal grants. So I often was in a situation where, as a tribal court, we had developed this really successful program, but the grant funding ended at the end of 3 years, and that meant that was the end of the program because we didn't have funding to support the ongoing programs that we might have been able to support with federal funding. So tribal courts are set up quite differently from state courts. And one of the aspects of that you want to think about from step one when you start understanding tribal courts is, are the courts in this tribe set up as a separate branch of government under the tribe's originating documents or not? So tribes have the ability to set up their own tribal courts. They can do it under the executive branch, so it can be kind of a program of the tribal council, or it can be set up as a separate branch of government that has similar kinds of authority to the tribal council. So one way of doing it is having the court set up as a program of the tribal council. There are other ways to do it, the most common being set up as a separate branch of government, similar to the 3 branches of government that we have in our federal and state constitutions. In our federal constitutions, it makes very clear that the reason for having these separate branch of government is to have checks and balances. So the judiciary is intended to be a check on the authority of Congress, on the authority of the executive. And if you have the courts set up as part of one of those branches, then they are acting under the authority of that branch, not as their own branch. So it sets up a very different relationship of the tribal court to the tribal council, depending on which kind of setup you're working under. So whenever I worked in a new tribal court, which was very frequently when I was a tribal court judge, my first question was, somebody have the Constitution. Can I see the originating documents of this tribe? Some of them would have, my own tribe, for example, has what's called referred to as an IRA constitution. IRA refers to the Indian Reorganization Act of 1934. And that act said if tribes set up their forms of government using a constitution that is similar to ours and it prescribes 3 separate branches of government, a legislative body, in this instance, that's a tribal council, an executive, which in the state of Washington is often referred to as the tribal chair. Where I'm from, we refer to those people as tribal governors. And then potentially a third branch, which is the tribal courts. If tribes took the opportunity to organize under that structure in the 1930s, they probably are organized still under that 3-branch government format. In the state of Washington, I've run into probably more tribes than I've seen in other states that are organized with the tribal court being a branch either of the executive or of the legislative branch, or sometimes they're kind of under both and are sort of more structured as kind of a program of the court. There are all kinds of different tribal courts. So one of the most common ways that you would see a tribal court functioning looks very similar to a state court. The Lummi Nation, for example, if you walked into that courthouse, which you can do, it's a public space. The court is, first of all, a public court of record, meaning that they keep records of everything that happens in court. If you need a transcript or recording of the hearing, they can produce that. They use databases that retain all of that information. And it's an open system, so that means members of the public are allowed to come in. It looks very similar, as I said, to, there's a judge that's sitting at a bench that's usually up high above everybody else. There are attorneys representing the parties, and it functions very similarly to a state court in many respects. There are also courts that are often called traditional courts or customary courts. Those courts function under the tradition and custom of the tribe that they serve, and they look completely different from a system that's more of a Western or United States style of court. Those courts can sometimes function entirely as branches of the executive. So in some of the tribes in New Mexico, some of the people that serve as governors or chairpersons of their tribe also serve as the judge, and they don't have a separate system. So if you have a legal issue, say with your neighbor over how far your property line is, sometimes that just gets decided by the governor in a meeting that sort of happens without there being a public record. It's just kind of a discussion, and things are resolved outside of any kind of traditional court that might be an obvious place where you would go file a lawsuit if you were an attorney. They just function in a way that looks very different to the traditional U.S. Western system that you might be used to. And then there are systems, and this is a system that is true for my tribe as well as lots of Pueblo tribes, and then there's lots of other tribes that have similar kinds of what I refer to as hybrid courts. And what that means is that it can function like a US-based system. So it looks like a state court when you walk into the courtroom, maybe. But the law is a combination of some law that the tribal council has adopted, that looks, again, very similar to statutes you might find that Congress has adopted. But there's also the use of traditional customary law in the courtroom as well. And that can mean that disputes are solved in a way that looks very different from the Western style court you're used to seeing on TV, or if you were to go into a courtroom, into any state or federal courtroom. And those hybrid systems can be complex to work in because, first of all, you have to figure out, is this a case that gets resolved in this community in a courtroom that I am used to practicing in, or does it get resolved through a traditional process and I have to figure out what the law is and how it applies in this case? I'll give you an example. So my tribe, the Pueblo of Isleta, as I said, has this kind of hybrid system. The story I'm about to tell you is fairly old. It's about 25 years ago. My tribe the court has changed a lot since the story I'm about to tell you. So things are not quite as confusing as they were in the scenario I'll share with you. But these issues still come up frequently in courts where tradition and custom gets wrapped into the resolution of legal disputes in the same way that a statute also could tell you what the answer is to a particular legal problem. So in my tribe, we're a tribe that was never relocated. We were never moved from our traditional home. And so the area where our reservation is now is an area that has been home to the Pueblo of Isleta for millennia. And that means that we have a very active language that is spoken daily. One of my grandparents did speak English, but rarely, kind of only when she had to. And while being bilingual in that way is very common in my tribe, there are very few people like my grandmother who were primarily Isleta or the Tiwa language speakers most of the time. Now most people have to speak English and their indigenous languages. My father grew up speaking English, Spanish, Tiwa, and Keres, which are the last two are two indigenous languages. And so he would have been quite comfortable being in a traditional court. When I was presiding, for a variety of reasons that are too complicated to get into now, but are related to the impact of federal policy on my family, I don't speak the Tiwa or the Keres language. So when I became a tribal court judge for my tribe, I was trained as a lawyer. I'd been to law school. I was a member of the bar. And I came into my own tribe's tribal court, not speaking my indigenous language, and not really knowing where to find the law if I couldn't find it in documents I could physically hold in my hand. And at that time, 20-ish years ago, when I first started being a judge, most of our work in the tribal court was work that was based on tradition and custom and tradition and customary law, which was only accessible through the use of judges and advocates who were not lawyers, but were trained as experts in custom and tradition and the language. So that set up a scenario where, just by way of example, where there was someone in our community passed away, and he didn't leave a will behind. He had been living with a woman for many years, over 15 years at the time he died, maybe even longer than that. He had a family prior to the relationship he was in at the time of his death. All of those kids were adults at the time of his death. When he died, he owned a house on the reservation in the village. The village that I come from, as I said, has been there for millennia. There are houses there that have been inhabited for hundreds of years all the time. And we haven't really built beyond the houses that have been there for hundreds of years. So who owns what is very important in my community, because if you don't own property in the village, you're not going to own property in the village in the future, because they simply don't sell these properties. They just get passed down through inheritance. So if you go back to the scenario that I was faced with as a judge in one of my first cases, I had a situation where we had someone who died who had property to distribute. They didn't execute a will to distribute that property. So I had to figure out what law applies. Is it the state of New Mexico where this person died? Does that law apply? So if that was the case, then I had a New Mexico statute that said if someone dies without a will, this is how you distribute their property. It lays it all out. If that didn't apply, then the next question is, well, what does apply? And in my case, what applied was the tradition and custom, but there were conflicting things. One person who was an elder in my community testified in court in the Tiwa language. I had an interpreter so that I could understand everything that was being said. So that I had one expert tell me tradition and custom would dictate that this person would be responsible not just for family number one, but also the partner he left behind when he passed, what we were calling in the court case family number two. So traditionally, his property that needed to be distributed should be distributed under a traditional process evenly between the adult children from family number one and the partner he was with for 15 years prior to his death in family number two. They did not have children. New Mexico law would have done something different. New Mexico law would have divided his property amongst his children, and the second family or the partner in the second relationship, because they weren't legally married, New Mexico law wouldn't recognize that. That's a pretty common statutory structure in the states. So I was told, I knew the first thing about New Mexico law. I was told the other thing about traditional law and how it would handle a situation like this. And I was told a third thing. The third thing that I was told was by an expert in traditional Tiwa law. What I was told was we don't recognize common law marriage. So even though there is an expectation in our traditional and customary law that the person who passed away would have his property divided equally so both families are supported, I also had this expert a different expert come in and testify and say, well, but we would never recognize family number two anyway, because they weren't legally married. There was no answer to this question. My job as the judge was to hear all of this testimony and decide which law I was going to apply. And I did that, and they appealed it, and it became very complicated. And you can hear from the very beginning, it was very complicated. The case went on for at least 18 months. It might have been 2 years before it was ultimately resolved. But you can see how these different ways of having a court system can impact an individual family and what's going to happen next in their lives. There's a wide variety of approaches to language in tribal courts. If you are from communities like mine, where the language is spoken very actively and it's very common, and most people in the community are going to at least understand the language, even if they're not fluent speakers themselves. The Navajo Nation has an extremely large and complex legal system. Much of it happens in the Diné language. And if you aren't a Diné speaker, then you may simply not have access to what's happening in the courtroom if it happens to be a proceeding that is happening entirely in the Diné language. That would never happen in a court, in a tribal court in Washington, especially a tribal court on the west side of the mountains in the state of Washington, because almost all of our tribes in the state of Washington were moved at some point from their traditional and customary homelands. And that resulted in the loss of language and a very dramatic loss of language. So there are many tribes where there are no speakers of the language, and there are many tribes that are working really hard to preserve the language from people who grew up speaking it, but are on the verge of losing that access to that language. So having court in that language would not be possible because it's simply not accessible information. So there's a wide variety of what that looks like. That's also affected by who your tribal court judges are. And this is where things really demonstrate the difference between state and tribal courts. Sorry, my light just went out again. I'm going to try to fix it. Hold on. There we go. Okay. Okay, so the first kind of judge that you would see in a tribal court is the kind of judge that you would see in a state court, someone who went to law school. The shorthand is referred to them as law-trained judges. So those are people that went to law school and became tribal court judges. And I'll talk a little bit more in a little bit more detail in a moment about who you might see as a tribal court judge. And again, it's gonna be different depending upon what each tribe's status is. Okay, there's also traditional, or what are often referred to as lay-trained judges. What that means is those are judges who are experts in the tradition and custom and the law of the tribe that they're from, but they didn't go to law school. So when I became a judge for my tribe, the chief judge was a lay judge, meaning had not gone to law school, but was an elder in the community, very well respected, and was an expert in the tradition and custom applied to a variety of cases. And in our situation, we had this hybrid system where some of the cases were resolved under ordinances passed by the tribe that you could see in writing, but a lot of the law came from tradition and custom that you would only know if you grew up there or if you had some way to access that information like I did by having people come in and testify about what the law is. Judges can also be appointed or elected. So in some tribes, people run for judge in the same way that we run in the state of Washington for our seats as judges. But they could also be appointed by the tribal council or by the leader of the tribe, or sometimes it's an action required by both the tribal council and the tribal leader, chairman or governor, to appoint someone for a period of some number of years. So when I was appointed to the tribal court at the Pueblo of Isleta, I was appointed by the tribal council to that position for a period of time. I think my original term was a couple of years. When I was appointed to the bench in Washington for most, if not, I guess for all of the tribes I worked for in the state of Washington, those were all appointed positions. I never had to run to retain the seat. In the state court system, we appoint judges if there is a vacancy. So today we just welcomed a new justice onto the state Supreme Court. She was appointed to fill out the remainder of the term of Justice Yu, who retired at the end of 2025. That new justice, Justice Colleen Melody, was appointed by the governor, and now she's also having to run an election to retain that seat. So tribal courts can look like both things. And so that's, again, another aspect of how tribal courts can look quite different depending on which system they have adopted. The tribal court judges themselves and who they are is also dependent on what the tribal council has decided. They might be required to be an enrolled tribal member of the tribe they serve. So some tribes say you can only be a judge here if you are a member of the tribe. Other systems may say you don't have to be a member of our tribe, but you have to be a member of some tribe, some federally recognized tribe, in order to serve as a judge here. So we don't require you to come from our community, but we do require that you know something about coming from a tribal community, and we vet that by saying you have to be an enrolled tribal member somewhere. And then there are some that say you can be a descendant of a tribe. So both of my children are not enrolled with the Pueblo of Isleta, and they are not eligible for enrollment with the Pueblo of Isleta, but they are considered descendants of a tribally enrolled tribal member, because everyone from their mother back were enrolled members of the Pueblo of Isleta. And so they are considered descendants. And so in some communities, they could serve as tribal judges if they ever decided they wanted to do that. And in some communities like mine, they would not be allowed to, because they are not tribal members. And at least at the time when I served, I think that's changed now, you had to be a tribal member to serve as a tribal court judge. So again, wide range. And then finally, you can be a non-tribal person for many tribes. There's no requirement that you be a tribal member anywhere for the vast majority of tribes that have tribal court systems and tribal judges. So tribal courts function with multiple levels of courts. So you might have a tribal court. Navajo is a good example of one, but there are lots of them that has a trial court where cases get tried, and then at least one level of appeal. Sometimes the tribes themselves have their own courts of appeals. Sometimes tribes will contract with something like, in the state of Washington, many tribes contract with the Northwest Intertribal Court of Appeals, which is its own entity that administers courts of appeal for multiple tribes in the Northwest. So that may be a way that people get to have an appeal, is to go through that system. And then finally, you may be able to access the case law that is written and published by those tribal courts of appeals. Many of the publicly accessible legal databases like Westlaw or Lexis, there's a number of others, but Westlaw and Lexis are the most common ones used by attorneys. Some of those, some published tribal court precedent is available now on some of those legal databases, and are actively searchable, and they are adding tribes pretty regularly right now. So much of that is accessible and published, but some are not. I've worked for some tribes who say you can only access that information if you're a tribal member or you practice in our tribal court. But if you're not either of those things, we don't have a public system and it's not accessible to you. So that's one of those things that people who practice in tribal court have to figure out the answer to all of these questions before they even set foot in a tribal courtroom. So the sources of tribal law I kind of described, but they come from tribal ordinances. Those are laws passed by the tribal council. So those can be criminal ordinances. They can be anything that you can really think of that tribes have the authority to decide. Again, those things may be accessible publicly, but they're not always accessible. So that's one of those things that you kind of have to figure out. The process of making decisions is very similar to state or federal decision-making authority. So judges, panels of judges, individual judges at the trial court level, that decision-making process looks very similar. It's accessing the information about what the law is in each jurisdiction that can be very complicated. Those decisions could make reference to state or federal law. When I was chief judge at the Lummi Nation, that there was something in the ordinance that said, hey, judge, if there's, didn't say it quite like that informally, but it basically said, if there is not a tribal law in this book that we've given you that has all our ordinances that addresses how to rule on a particular kind of case, then we direct you first to federal law. If there's nothing in federal law that gives you the answer, then you can go and look at state law. And some tribes will say, you can look at federal law first. If there's nothing in federal law, so for example, you pursue things like family law cases, divorces, child custody, those kinds of things in state court or in tribal court, but you can't do it in federal court. So there is no federal law that lays out what the federal law of divorce is. It just doesn't exist. We've left that entirely to the states. So if there's nothing in the tribal law that told me you can go look at federal law and then state law, then I had to go and figure out, is there a federal law for this question? If so, should I apply it? Should I go to the state law? And so some ordinances would give me that information, some wouldn't give it to me at all, and I had to figure it out for myself. Most of the decision-making that comes out of tribal courts involves community values, community concerns. So when I was sitting in tribal court as a judge presiding over a criminal case, one of the things we always did was plan for what happens when this person who has now got a jail term they need to go serve. So I've sent them to jail for 3 months. We start planning that day in tribal court. What happens to this person when they get released? How can they be successful and not commit a new crime? How can we set them up for success? So where are they going to live? How are they going to complete their probation requirements if they have them? How do we support them so that they don't go back and start using again? These are all these questions that all judges think about. But in the tribal court system, it's very common to begin planning for those people re-entry into society immediately. In my experience on the state court side of things, that is almost never a question. If we do have some ability to monitor someone's compliance with a court order when they're released from being in prison or in jail, if we do have an ability to order some kind of probation style of supervision, very often that supervision is very tenuous and quite limited because we just don't have enough probation officers. In my tribal court system, oddly enough, we had, when I put people on probation, we had probation officers who were able to monitor the person's requirements and make sure that they were following through on getting to treatment if that was a requirement, or ensuring that they don't violate a no contact order if they're prohibited from contacting their ex, for example. We could supervise those things, whereas in the state court system, those things don't exist for the vast majority of people who commit felonies. So one of the things that matters in tribal communities is that when you're a tribal member, we care for you whether you are whether you've got your life together perfectly or you don't and you're getting into trouble. You're still a member of our community. What I've seen on the state court side of things is that for the most part, when someone commits a crime, we start referring to those people as criminals, and we don't think about them again unless they get into more trouble. And then people get mad at the legal system for not preventing those people from getting in more trouble. But we don't fund the legal system to the point where we could successfully supervise those people and set them up for success. And so we're kind of just doing the same thing over and over again and being surprised that it doesn't work because we don't have good solutions to those things. But in tribal courts, because we have a lot of flexibility, we could incorporate, and we are expected to incorporate, community concerns and community values. So I'm just going to share a couple more thoughts and then I will open it up to questions. But I want to talk very briefly about how the role of the judges are different. So I've talked about the difference between law and lay judges. And I will say that when you're in a courtroom that is run by a judge like me that's been trained in the law and how to think about the law in a certain way, the court runs one way. if you're in a courtroom with a lay judge who's familiar with the customs and traditions and the law of that tribe, the courtroom runs a different way, because that person is always going to be from that community. They have pre-existing relationships with the people in their courtroom. Those relationships are going to continue after the judge is no longer sitting in as a judge, and they're just neighbors. So it's a very different kind of relationship. The expectations in tribal communities of what judges do is totally different. It's, in fact, in my experience, the inverse of what we expect from state court judges. In my work as a tribal court judge, the expectation was always that I was a part of the community and that I would learn what the cultural expectations were of that community. So I was always in a learning capacity, learning a new community's approach to dealing with drug addiction, for example, or the way the community handled juveniles who were getting into trouble. And so I could create programs around the values that the community was trying to express through the operation of the tribal court. In the state court, there was none of that. We don't go beyond what the statutes tell us our authority is at the level of the trial court. And when you get up to the level that I'm at the Supreme Court level, where the Supreme Court is only taking a handful of cases a year and only deciding those cases where there's a conflict of law between our various divisions of the Court of Appeals, and that means that there's a question of Washington law that must be answered. But we, at this level, at the Supreme Court, almost never see the parties to that case. And we almost never think about what are the values that are being embodied in the statute that we are now in the position of explaining how to work with that statute. So that means then that when I would serve as a tribal court judge, I was trying to figure out what matters to this community. One of the ways I do that is by understanding the sense of humor of that particular tribe, because in tribal communities, we communicate first through humor. But when I worked for the Lummi Nation, and at the same time, I also worked for the Nooksack Indian tribe and the Upper Skagit Indian tribe, which are 3 tribes in the Whatcom-Skagit area that are within 50 miles of each other. Each of those tribes had very different cultural values and expectations, but they were all very funny. But the thing that I learned very quickly working with each of these different communities is that they were funny in different ways. Something that I could say was amusing at Lummi was just fall completely flat at Nooksack. It was very stark, the difference. So what that meant was that what we're expressing as what is funny looks different in Nooksack than it does from Lummi, and that's different from Upper Skagit, and that's also different from the Samish tribe, which is down the road. So the expectations of what I did as a judge changed depending on what community I was in. Whoops, sorry. I just somehow jumped back. I didn't mean to do that. Okay, so then I'm just going to very quickly go over what tribes can decide, and then I'll move on to questions. So tribes have the authority under this whole rubric. So now I'm kind of going back to that very first slide where I talked about treaties and how tribes' authority is kind of captured in the relationship between the federal government and tribal governments. Tribes can decide intragovernmental affairs, which basically means the best example I can give you of this is who's a tribal member and who isn't is a uniquely tribal decision that our case law on the federal side and to a certain extent state court, a couple of state courts have had to deal with this question. Who is a tribal member is something that federal and state law agrees is entirely a matter to be decided by that individual tribe. So some tribes like mine require that you be 50% Isleta, that you can demonstrate your ties, or 50%, meaning typically that means one parent was 100%, or excuse me, yeah, that's how it works, 100% Isleta in order for me to be a tribal member. You can imagine that those numbers get smaller and smaller with that high of a requirement to be a tribal member. So in my tribe, that has gone down from 50% to a quarter fairly recently. And then there are other tribes who don't use family tree at all and instead use cultural touchstones in order to decide who is a tribal member and who isn't. Is this someone who speaks the language? Is this someone that understands our culture and traditions? Did they grow up here? And then there are tribes that are kind of in the middle where they might decide tribal membership by descendancy, which means the Cherokee Nation is an example of this, that says if you can show us that you've descended from someone on a census that was taken in 1910, then you are eligible to be a tribal member. So that's an example of an intergovernmental affair. The jurisdiction tribal courts have over criminal matters is extremely complicated. I used to teach a quarter-long class on that alone. But most tribes are able to decide anything that happens within the boundaries of the reservation that happens, that's committed by a tribal member, by someone who is a member of a different tribe but lives on that reservation or committed the crime on that reservation. There is almost no situation. I think there's 2 situations, but for the most part, if you are not a tribal member, meaning you're not a native person, but you commit a crime on the reservation on tribal land, only the state court or the federal courts can prosecute you. The thinking being non-tribal members don't have any ability to impact what happens at the tribal council because they don't have the right to vote. So that means that they can't be brought into court either, into the tribal court. So you can imagine that sets up all kinds of terrible problems for tribes. It's one of the reasons that human trafficking and drug trafficking happens on tribal land at such alarmingly high rates, because people who are involved in the movement of illegal drugs through the United States know if they travel on roads that go through tribal lands, they are less likely to get picked up than if they are doing that on the state side of things. So that's given rise to tremendous numbers of problems with trafficking issues on tribal lands. Very complicated. Similar problems with civil. There's more jurisdiction on the civil side for tribal courts, but there's still restrictions about what kinds of matters tribes can hear. So at this point, I'm gonna just say one other thing, and then I'll take questions. Tribal courts really function on the idea that what we do in our court systems, what is justice, is our values. And so I love this quote by Dr. Cornel West: "Justice is what love looks like in public," because I think you can. If you think about justice as the legal system, you can immediately see that we are not engaging in the process of caring for our communities in most of our state court systems, particularly people who are in trouble in our state court systems. And if you think of justice in this sentence as engaging in acts that result in a more just society, then you have a different legal system. The system looks different, and it looks a lot more like what we refer to in a shorthand as therapeutic courts. And there are all kinds of therapeutic courts and tribal courts that state courts can learn a lot from, because it starts with the idea of, you have a problem that's getting you into trouble. Let's solve the problem. That's basically the idea of therapeutic courts. They often require people to come to court every week and check in with the team. If it is a therapeutic court that is addressing substance use, then that's what we focus on. If it's a therapeutic court that works on behavioral health issues, those exist. Mental health courts is what they're often called. Those are structured to create a kind of a set of enforced boundaries around someone, so that they can over time rebuild their lives in a safe way as possible. Those demonstrate some key values of community, tradition, and problem solving. Those ideas have been used in a lot of state courts, therapeutic courts, drug courts, veterans courts, mental health courts. They really come from this process that we see in a lot of tribal courts of trying to really come up with just solutions. And so that's the place where I really hope state courts engage in working with tribal courts, because I think that's a place where tribes have a lot to share and teach our state court counterparts. So I'm going to stop the video at this point, and I'm happy to take questions if you have them. I went a little longer than I planned to, but I am happy to hear from you. Thank you.
We have time for 1 or 2 questions.
Great.
Please make them brief. No, we're recording them, so we can't.
Thank you so much. So I was wondering, what are kind of like either tools or the general possibilities for addressing kind of, I think something you mentioned in the ways that the tribal court is not really allowed to or given not the jurisdiction to recognize or interact or address essential issues like disproportionate violence against indigenous women, especially. Like, what are the tools and possibilities that exist either high judicially or within tribal courts to work on that?
So there's the first part of the answer to that question starts with something called the Major Crimes Act, which you can Google. The Major Crimes Act was passed in response to a U.S. Supreme Court case. And that U.S. Supreme Court case said, if the tribe has their own tribal court and they successfully hold someone accountable for the crime they committed, in this case, it was actually a murder. This is a case from the late 1800s. Then they should be allowed to do that. It's part of their intra-governmental authority. Congress did not like that because they didn't understand what tribes were doing in their legal systems, because the systems didn't look like the systems they were used to. So they passed the Major Crimes Act, which they effectively said anything that's a felony, but certainly things that are violent crimes, murder, sexual assault, kidnapping. There was a list initially, I think, of 5. The list is now much longer. Then those cases can only be prosecuted in federal court. So if you are a tribal member and you commit the crime of kidnapping on the reservation, that case cannot be prosecuted in tribal court, or if it is, the sentence is very limited by congressional authority, which has said tribes can't give jail sentences of longer than, I think now it's 3 years. When I was practicing, it was 1 year. So that means that very serious crimes are the responsibility to be prosecuted by the United States Attorney General's office, the Department of Justice. If you have a Department of Justice that isn't putting a lot of effort towards investigating crimes, and the investigating body is the federal government, or excuse me, is the FBI for major crimes. If they're not involved in investigating, and then the Department of Justice chooses not to prosecute, you really don't have any access to the legal system in any capacity, in the tribal court or in the state court. Many, and when I say most, I mean by far, most major crimes are not prosecuted when they occur on the reservation. If they are crimes that get a lot of public attention, that will get the Department of Justice to act. If there are individual good working relationships with the Department of Justice, like there is in the state of Washington with tribes, they might act. So in Washington, we have a better prosecution rate than we see in other places. But getting at those larger issues that you're talking about without there being political will at the federal level, it doesn't happen. And so what that means is, for example, I saw all kinds of evidence as a judge of not just human trafficking happening on the reservation I was working at, but the trafficking of children. The federal government, for whatever reason, chose not to investigate that. So it was just happening as a matter of course without any consequence. That's changed because the federal government and the Department of Justice in the state of Washington has been more active in trying to address the missing and murdered indigenous women issue and the trafficking of children, but it still happens. And it is effectively, there's not enough political will, and tribes don't have the same kind of political authority as lots of other constituencies. And so they don't get the attention of Congress. And so the law remains the same and the issues remain the same. It's a depressing answer, but it's the truth. It's what happens.
Hello. I have two questions, one that's probably pretty easy to answer, and then one that's a little bit more complicated. So I was wondering, for Public 280 tribes, can they establish courts, or have they prevented them? Are they prevented from doing so?
Yes, they can establish courts. Public Law 280 is another federal law that gave state governments the authority to prosecute certain kinds of crimes. The best example I can give you is juvenile cases. So I had situations at the Lummi Nation where a kid like tagged a building. They were being prosecuted by the Lummi Nation Prosecutor's Office and by the Whatcom County Prosecutor's Office. And they had two different court orders that they were required to follow. This is a 14-year-old. Those court orders were in conflict with one another. He couldn't successfully comply with the tribal court order without violating the state court order, and vice versa. That's a result of Public Law 280. In some respects, it can work really well if the state and the tribe happen to have a good relationship and work well together. If that's not happening, then you often will see, so for example, if the prosecutor's office says, we think you're too easy on juveniles, and they're implementing a practice that recognizes brain development in the tribal court, which was that's kind of my thing when I'm working on juvenile cases. You can read some of my case law that I've written as a tribal court, or excuse me, as a state Supreme Court justice that talks about my approach to juvenile cases. That looks different the way that I do it and the way that I did it in tribal courts. But it often made the prosecutor's office upset. And so they would prosecute because they could impose a sentence that was more in line with what the state law approach was. So the answer is yes, can create all kinds of problems.
Thank you. And then my other question was about the appeals process and the tribal consortiums.
Mhm.
And I was curious, so my aunt, she works for the Nooksack tribe, and she runs into issues because she does alimony collection and child support collection, and particularly when there's two parents and one is from another tribe, collecting child support can be an issue when the tribe won't recognize that child support. So in a consortium situation where you have a decision made, do you run into tribes not recognizing that decision and trying to appeal further, or do you run into conflicts there?
You definitely run into conflicts. For the most part, there's nowhere else to go. So if you exhaust your appeals remedy at the tribe that you are in the tribal system that you're in, that's the end of it. So occasionally, sometimes people will try to take something to federal court. For the most part, those get kicked out. So really, when you're done with the tribal appellate process, that's the end of your case. Same is true on the state court side of things. If you get to us at the Supreme Court and we don't take your case, that's the end of your case. In terms of tribes recognizing each other's tribal court orders, that is a set of problems that are beyond the scope of my ability to solve. So I haven't thought about them recently, but it comes up very frequently for lots of different reasons. If you're a tribal court that says, hey, anybody challenging a child support order gets an attorney. In the tribe that issued that child support order, they didn't get an attorney, so I'm not recognizing that order. There can be valid reasons to say I'm not going to do what tribe A says because at tribe B we do it differently. That can be a valid reason. It still has to get resolved because you are in a situation where there's a court order that's not being followed, but it can create all kinds of problems.
Raquel, I have a question here that comes to us online from Fairhaven alum David Trapp. David says, thank you for this presentation. I work with reentry support organizations in the Northeast, and I'm curious if you have seen or know of any instances where a tribal structure or approach post-incarceration as a model, essentially, has been successfully implemented either in full or part in non-tribal situations.
I have never seen it done. I think there's lots of ways it could be done, and lots of ways in which I think it can be successful. The place where I've seen the most successful use of a tribal court strategy has been the use of what people are now kind of blanket refer to as restorative justice. That can be peacemaking circles where the victim and the offender are both in the room and everyone supports them as they go through a process of understanding each other, I guess is probably the best way to phrase that. And some of those, it's hit or miss. Some of those are implemented very successfully, some are not. What we try to do in the state court system is we often see a good idea, but we want to simplify it so it's something that everyone can do. But in the case of things like restorative justice, you can't kind of pick and choose. So it often doesn't work. It doesn't translate well if you haven't done the work ahead of time to get everybody ready to do something that is different. So I have not seen much success.
We have a final question.
Okay.
I'm thinking about the Indian Child Welfare Act, but why is it that sometimes the federal government will step in and decide where a child what family it will go to, or if it will go to foster care instead of the tribal courts deciding?
The federal government will never do that. They used to. They don't really do it anymore because of the Indian Child Welfare Act, which was passed in 1979, that changes the way in which we make decisions about when children get removed from their families. So I don't really have time to explain that in any detail, but what has happened since the passage of the Indian Child Welfare Act has been that there's been a real effort on the part of many, if not most, state courts to work well with the tribes where they see the most kids coming into foster care from, to follow what we call placement preferences under the law. And those placement preferences basically say, if you're going to remove a Native child from their family of origin, you have to demonstrate that that child is in imminent danger of physical harm from their family member. It's a very high bar. Once they're removed, if you've met that bar, then the federal law says, state court judge, you are only allowed to place that child in a non-Indian family if there are no other relatives or related family members or members of their own tribes who can provide temporary care for the child while we're working on addressing the issues that gave rise to them being in the system involved at all. So the short answer is federal government never steps in, but they have passed a law that tells state courts how to work with Native families to try to keep those families and the culture intact.
Okay. Well, we've reached just about the end of our allotted time, so please join me in thanking Justice Montoya-Lewis being here with us today.
Thank you. Next time I'll be in person. All right. Thanks, everyone.